That is a very, so when you get us together, we find at least 3 things that the other person says, which is very interesting, and 4 that we disagree with. That is the point here, too, the subtlety of this view where you look to conditions really in the world in light of the value, is that it is complicated and subtle. For example, there are a large number of states that did have on the books statutes that said you can execute someone under the age of 18, say a 17-year-old. But if you look at the number of states where such executions occurred, there were virtually none, very few, very few. And then if you looked around the world, and this was very controversial whether you should say this, but if you looked around the world, we were the only country in the world, indeed, in practice, that did such a thing. Is that relevant? Well, you know what the framers said about whether it's relevant? What do you think they said? Nothing. They told us nothing about it. And if you look to see what they did, sometimes they looked abroad to certain places. Sometimes they didn't. Hence, there is ground for disagreement. One other point, and that is, in respect to the question of leaving things up to the elected branches, neither the originalist view nor the view of what I'd call more flexible, let's call it, why, evolutionary sounds a little odd. Let's call it, what should we call it? I want some positive thing here. What about concerned with the conditions of life? What about, well, in any case, you see what it is. It's hard to predict which view will lead to greater freedom for the electorate to change things. Yeah. I cannot resist pointing out that if you look at the numbers, probably I have been more willing in constitutional cases to allow the electorate to choose matters for themselves than some of those who hold the originalist view. So that's a wash.
Oh, I doubt that. But, I mean, the question is, who made you king? I mean, the world has changed, but who placed it in your hands to change our Constitution the way you think it ought to be changed in order to account for these changes? And the people can do that. They can abolish the death penalty under 17. And as for the notion, well, they had it, but it's very rarely used, it's also very rarely used to execute women. Now, are you going to abolish, is that the next case we have? You're going to abolish the death penalty for women because it's very rarely used?
I never discuss a case that hasn't arisen. The interest here is, of course, I don't believe that I'm changing the Constitution. I believe what I'm doing is taking the unchanging value and applying it to the circumstance today. And the reason I don't think it helps one side or the other in this debate to appeal to the importance of democracy is that both groups of people, in the judicial world, in the academic world, believe that this Constitution is basically about democracy. It basically sets up a system so that the people themselves, through the democratic process, can decide what to do. It doesn't give us the power to be kings, but it does give us the power to patrol the boundaries. Now, those boundaries are interested, among other things, in protecting individuals, minorities, others from the tyranny of the majority. And what Hamilton thought and Madison thought is that it would help in that respect for a group of unelected judges sometimes to be able to say when, for reasons that they write down, an action by the majority is in violation, is a kind of tyranny, does interfere with those rights. That's where we get the power, and we don't always exercise the power in ways that command unanimity in this court.
Hamilton would jump out of his skin if he thought that the Constitution he supported allowed 9 unelected judges to change the meaning of the document from year to year. And as for the fact that the evolutionary view is a defender of democracy, every time we make a Bill of Rights decision, it is an anti-democratic decision. The only thing that enables us to do that is that the people themselves authorized us to make that decision. The people themselves said you can't quarter troops in homes, even if the majority wants to. The people themselves says you cannot suppress freedom of religion, even if the majority wants to. The people said those things. But they never said, for example, to take what here in Washington is called the Big A. They never said a state cannot place limitations upon abortion. Now, there are views on both sides of that, and once again, I'm officially neutral as to which view is the right one, but do not pretend that it is not a limitation upon democracy for the Supreme Court to say the people cannot place limitations on abortion even if they want to. That's a limitation on democracy.
No, we had a case, which I'm trying to get away from such a controversial issue as death penalty.
Well, the controversial issues are the better ones.
But this is controversial.
They're the ones that get the blood flowing.
This is
you see what's at issue.
But there is a good. This is a case this is the kind of thing that's more often at issue. There's a clause in the Constitution that says you cannot have an ex post facto law. Now, what's that? Good. What?
When you charge a person with a crime that they committed before it became law.
Absolutely. Here we have the following case. California passes a statute that makes it a crime, which has always been a crime, a certain awful thing involving molesting children. But what it does in this statute is it says the statutes of limitations, you can't prosecute a person for in many crimes after a certain period of time expires. That's a statute of limitations. It used to be 3 years. That was the statute of limitations for this crime. 3 years expired. 20 more years went by. 20 more years. Then they pass a new statute and they say, we extend the statute of limitations backwards, and they charge someone a quarter of a century after the incident that they said was the crime, and about 20 years after the statute of limitations had expired. Is that an ex post facto clause, violation or not? Now, that's a hard question. So, one group of people on the first method will look into the history. I'll tell you one thing about the history. The history requires the court to look at what a judge in the early 19th century wrote about an 18th century treatise writer called Blackstone, who was writing about an incident that happened in the British Civil Wars involving imprisonment in the middle of the 17th century. Now, I say, if that's the kind of thing that we have to look to all the time, you better select a historian to be a judge, because I am not a historian, and I'm the first one to admit I know virtually nothing about that. And in that particular incident, well, the historians disagreed about what it all meant. But I'd say the value-laden method tries to identify the values that underlie the ex post facto clause. It says, why do we have such a clause? What are we trying to prevent? What kinds of unfairness? That's what they're interested in, and then see if you can apply that to the modern circumstance. That isn't changing the meaning of the Constitution. It is applying the Constitution. It's emphasizing different kinds of sources when you try to identify that meaning. And by the way, you can look it up, see in recent times which method has set aside the people's democratic action the more. I happen to know the answer to my question, and I wouldn't bring it up if it didn't favor my side. In other words, less. In other words,